All right. Hello, everyone. I have been putting off making this video for quite some time. I was kind of hoping to be able to do some fancy graphics and whatever in the background, but this is a popular topic, so I wanted to just get something out there quick and uh, useful, and then have you all kind of guide the discussion what additional information you would like to see. So this is always a popular topic with both or all law enforcement, um, home defense people, um, attorneys, lawyers, even judges don't understand the exact mechanics of a um, deadly force use. Um, and then obviously fiction writers, people who want their storylines to be legally consistent with the way the world works out there. So luckily, all of those, everyone interested in deadly force, it all revolves around one statute, one federal statute, which is the Federal Rules of Criminal Procedure, Rule 12.3, Public Authority Defense. So if you don't remember anything else from this video or you don't get anything else from there, write that down. Um, you don't have to go out and buy anything. Those are available online for free. I know Cornell Law has a has a um, has the entire U.S. Code Service available to view online. So Federal Rules of Criminal Procedure, Rule 12.3, Public Authority Defense is what we're going to be talking about here, and what is going to interest you either as a law enforcement official or for home defense. I can't tell you how many times, how many police I have spoken to, and I've asked them, well, what are you going to do in a job-related shooting? And the answer has always been, um, we'll just let the lawyers figure it out. Or someone who's interested in a home defense, use of deadly force at home, um, who just say, we'll figure it out once we get there. So, as any first responder will tell you, an emergency is the worst possible time to plan for an emergency. So, having a plan going into even carrying your Binford 6000, disruptor rifle and jet propelled ammunition, you need to include the Rule 12.3 Public Authority Defense in your arsenal. Um, so what that rule states um, is that you're because you're going to be crime, you're going to be, if there's a body with your bullets in it, you're going to be charged with homicide. And that's not up to the prosecutor, it's up to the coroner. The coroner is going to file a complaint on behalf of, obviously, the person who can't speak for themselves anymore. So that charge, the law is awakened by a complaint, has to be put back to sleep with a verdict. So they're going to fill out the death certificate and they're going to leave the death certificate cause blank. And so they're going to come at the circumstances under which that person passed away, looking, obviously they're dealing with a homicide. So what you need to do with the Rule 12.3 Public Authority Defense is to be able to prove to a prosecutor that they could not get a indictment past a grand jury on you because of the circumstances of the shooting. That's for police. It's very easy. They have the car. It's black and white. They have the lights on the roof. They have a uniform with a badge on the uniform. It's very easy to show a grand juror that you have the law on your side. Where that becomes, I'll tell you right now, it's very, very unlikely you're ever going to defeat a uniformed police person in a shooting situation legally. Every jury is going to agree with them. So it's best in those situations when you're asked to comply by a policeman, just uh, immediate and total compliance with a uniformed police officer is the only you're not going to have any defense if you don't do that or if you respond any other way. So, but that said, what the rule 12.3 states is that you were either working for a police agency or a law enforcement agency or believed yourself to be. It's a very key phrase in that rule. You believed in your heart of hearts that you had the law on your side. It's very important because in order to get a conviction against anybody or someone for any crime, the prosecutor, the state, has to prove two elements. Number one is an actus reus. It means it's a guilty act that a crime was committed. And the second part is mens rea, that a guilty mind was behind the act. So the prosecutor must prove both of those elements. One of them is missing, you're going to walk. You're going to get an acquittal. Maybe not in the initial trial, but you will in an appeal. A murder case or a homicide case is always going to get appealed. So prosecutor wants to not hand over grounds for a acquittal or either an acquittal or getting it thrown out on an appeal. So that intent is very important. So you run over somebody in your car, and you didn't mean to do it. That's an accident. You did not have criminal intent. Your intent was to go about your business, and you accidentally ran over this person. So that's not a crime. I mean, if you were drinking or whatever, they may be able to get you for manslaughter or something, but it's not homicide. You didn't seek out that person to run them over. If you went gunning for that person to run them over, then you had criminal intent. You wanted to kill them. Then that's going to meet the mens rea requirement. You're going to, as long as they can put your fingerprints on that steering wheel, they're going to meet that requirement. They're going to get a conviction. So that's that belief in your heart of hearts that you had the law on your side is your only protection against a homicide case or homicide charge. So in law, there's very loosely defined, but it's very important for what we're talking about, concept of the oaken door threshold, which states that there's a space around you, all of us, that's roughly 6 feet or so in diameter. It changes, or it's different for different people, to where a reasonable person, a juror, would believe that you had adequate provocation for defending that space. If somebody came into your space, you would have adequate provocation for shoving them out of that space or filing a complaint against them that they came at you, veins standing out of their neck, and they were in your 6 foot diameter. So adequate provocation is a very important concept for what we're talking about. And um, so what you another important an important element to the um, open door threshold concept is if you go out in public, if you seek out a confrontation, like if you go in a bar and where everybody's drinking and causing ruckus, and you deliberately provoke somebody into that encounter, that violent encounter, that is not you're not going to pass the test that you had the law in your heart of hearts that you were trying to help your community. So that's um, the circumstances under which you put yourself in that position are going to be examined in that initial determination to decide if you're going to get indicted. But if your home or property that you are being in custody of, your buddy leaves you in charge of his house, says, hey, can you take care of the place while we're gone on vacation, whatever. You have an expectation, you believe in your heart of hearts that you're in charge of that property. If somebody intrudes onto that property, then they're subjecting themselves to a deadly force situation. The key to that, and this is very important also, the key to the open door threshold defense, or the adequate provocation defense in an open door threshold, is confinement. Did you have an opportunity to escape? Could you get the kids out the window? Could, was there, if this guy jumped in your face, were you able to get out of there? Or did that person restrain you? Did that person hold you into that, physically hold you into that position where you couldn't escape? That's restraint. Restraint is always, always, always going to pass the adequate provocation threshold. So, and that goes for for police. They, paperwork error, whatever it is, they need to take you downtown in handcuffs. They're going to restrain you, but they're number one, they have received training to be able to be responsible for your safety while they're doing that. And then they're legally responsible for what happens to you if they're restraining you under the law. So, but if you're trapped in a situation that you cannot escape safely, and you feel that it needs to be dealt with, and you're armed, then you're gonna have grounds for 12.3 public authority defense. So read that statute, familiarize yourself, put it in your arsenal, so that it's going on in your brain in situations that you're encountering out there or at home. And keep it in mind that that's what a jury or a grand jury is going to be looking at in making a determination whether you're going to get hit with homicide or you're going to walk. If they know they can't convict you, you're going to walk. And so I don't want to hit you with too much, but that's, or to begin with. So focus on those areas. The Rule 12.3, public authority defense, the open door threshold, restraint. You don't want any restraint. And then I'll add some more if we get some feedback that you all would like more information about that. All right, let me kill this for now.